God. Now, there's been a lot of conversations after Thursday's incident where the Speaker of Parliament communicated to the House in relation to some 4 seats. Three on the side of the governing New Patriotic Party and then one on the side of the NDC. And this was because three of them had decided to go independent, and then the other who came in as an independent has also decided to go and on the ticket of the NPP. And after that, we've had the NPP group in Parliament also go to the Supreme Court, and the Supreme Court has frozen that ruling or information given to Parliament by the Speaker. Now, there are a lot of expectations and everything. But first of all, what do you make of all this brouhaha and the back and forth in relation to this particular issue?
I think the problem in Ghana is that we have to politicize the country to such an extent that there's never a cool time where people can use their cool head and dialogue. Or even argue, if you like to put it that way, I don't mind. I mean, people can argue about issues, but in the end, there has to be a solution. The Constitution has provided a third arbiter, which is the courts, that if there is a misunderstanding on a particular issue, the courts can decide. The contention by some to say that the Speaker got information. If I listened to the argument, in fact, the whole of the play that took place in Parliament, there was a motion by some people to say that the people who are no longer members of Parliament. And they argued, and the Speaker made a ruling. Then they said it is an information, which I am unable to understand. Speaker makes a rule, always makes a ruling. That is his job. So if he makes a ruling, why are they arguing that it is not a ruling? That is neither here nor there. Whether it's a ruling or information, he made a pronouncement.
Okay.
And that pronouncement was the basis for which the others who disagreed with him said, okay, I'll go to court. So they went to the Supreme Court. Now, the Supreme Court's order is what we call interim. It's not final. That's why they give 10 days within which others should file documents so that they can act to and make an argument. They are attacking the Supreme Court, which particularly the lawyers amongst them. This is the one I found surprising. Why are you attacking the Supreme Court? If a person brings an application, normally you have to stay the process. You have to stay the process in order for them to come and argue. When they argue, you can make a final ruling, which can go one way or the other. So this brouhaha, then they are postponing, we will repeal this, we will repeal. Just don't wait until the final decision is taken. If you are now the majority, you can go ahead and whatever you want to say, you want to do. So this is my view of this matter, that there is no effort in this country to have dialogue. Or even, as I tell people, I say, we can even agree agreeably.
Agree to disagree.
Exactly, can agree to disagree. So there is no need for all the creating tension, judges, they are even naming them. It's not done. It is not done because you are making the public to have what you call hatred towards those judges. And it was this of behavior that culminated in the murder of the judges. So this is what I'm just cautioning people to say, that don't do that to the judges. The view is to based upon law. There are 5 judges who took the decision. If you disagree with them, you can even assume that you disagree.
Okay, we'll have to re-establish contact with Sam Okudzeto. The line is deteriorating, so we'll try and reconnect with him. At a point, the line was getting choppy. We couldn't really hear what he was saying. But he says that as a country, we don't give room to dialogue, and we should agree to disagree. But a lot of the times, the politics is so intense that we don't want to find reason in each other's argument, or even come to a certain agreement that, well, after we disagree, let's proceed. And he's saying that we should tread cautiously, especially in relation to how we address the issue of the judges. And he maintains that what the speaker did on Thursday was not an information, but rather a ruling. Sir, can you hear me?
Loud and clear.
Okay, fantastic. Yes, so you were talking about how it is not healthy and it's worrisome that people are overly attacking the judges, and even to the extent naming them and trying to
You don't do that. You don't do that. It is not healthy. A court has decided. The Supreme Court is composed of so they say they pick this person and that person. I'm saying that if 5 judges even take the final decision, what they've done now is just interim, which is the process by which they should do in any case. Because I always give the example. If, for example, you have your building, and then someone comes and disputing that the building is going to demolish it, and he brings bulldozers and the rest on the ready to go and demolish your building, what will you do? You will seek help, won't you? And that is the process where you go to court. In fact, when you go to court, according to our constitution and our law in Ghana, it can be one single judge of the Supreme Court that you can go to. You can go to even one who will make an order immediately to seize that until the issue is determined. That's all they have done now. It is not a final decision. If they made a final decision, you disagree with it, you can still ask for a review. These are all processes which are laid down under our constitution. And our lawmakers who are supposed to understand this are taking the whole thing as if we are in a battlefield where somebody is shooting, you have to shoot that person down and so on and so forth. I think it is not healthy.
Now, so at the moment, the two sides are, claiming to be the majority, and they have indicated that they will assert their rights as such come tomorrow when the House resumes. What can be done about it, or what are your thoughts on that, especially when the two sides are asserting that they're the majority? I mean, many people foresee chaos.
Well, how will the Peace Council can do something, because some of us, they even classify that as MPP. So whatever we say, they don't even want to understand as elders of the country who have seen.
Sir, a moment, please. I lost you for a moment there. You were saying that the council should intervene. Is that what you were saying?
I said the Peace Council should also intervene immediately.
Okay.
Are you getting the picture?
Yes.
Yes, that's what I'm thinking. Because I said there are some of even classified us as if we are MPP, therefore not open. But the question, of course, is that it is our country. If there is a chaos in the country, we are all losers. And sometimes I even want to say, you don't know who will perish in the process. We don't know who will perish in the process. But innocent people can lose their lives in the process. So let's just be cautious and realize that we have a country. And we need to protect that country, no matter what. So a cool head is required in this matter. So just let them be cautious. But I say I'm appealing to all the chiefs, what's his name, Peace Council and all that. Everybody should try and see intervention. They can be to talk to them to stop the quarreling. Wait until they go and present their matters in court. They let the court make its ruling. And as I said, the ruling is made and you disagree with it. It's a right of review, which is by the Constitution.
Now, one of the main issues of contention, or that has turned this whole issue made it very contentious, is the argument being made that this particular ruling is not new to the House. That just in the year 2020, the then Speaker, Professor Aaron Michael Quay, declared the Fomena seat vacant because Andrew Esiama at the time had filed to contest as an independent candidate. And so how is it that it was no issue then, and all of a sudden 4 years down the line it's now an issue?
Well, don't forget that in that particular instance, actually the fact was that it was the NPP who wrote to Parliament to say that the man has ceased to be a member of Parliament and therefore he should be expelled. I remember that is what happened.
Mm-hmm.
In this particular instance, there was no such thing coming from the party to Parliament. And so the Speaker was making to make a ruling. And I said that under the Constitution, if there is an issue as to whether the person is meant to be a member of Parliament, there is a right for you to apply to the High Court for a declaration to that effect. But Ayanika is saying that because he says shall, it means the person himself should remove. And I said, no, you're completely misconstruing the language. If say shall does not mean that that person by himself. Otherwise, where would the provision be made in the Constitution to say that that matter can be determined by the court? So this was the matter, because what the Speaker was doing was virtually interpreting the Constitution. And I believe that this may be the reason why these people have jumped to the Supreme Court instead of the High Court.
Now, other arguments have been made that they don't necessarily, the information doesn't necessarily have to always come from the political party. As has been argued by, for instance, Professor Aaron Michael Kwe, and then you equally reiterating the same points. The others who hold the yes.
No. If it can be made by any individual, can go to court to make that to ask for that declaration. Any member, any Ghanaian, any citizen who can have a right to vote can actually go to the court. But I'm saying that since the matter was raised by the opposition in Parliament, and the Speaker made a ruling, that is where the whole thing changes. But I hope that's clear.
But in this particular situation, the Speaker based his ruling information on the notice of poll, which he said was significant enough to communicate that these individuals had taken precise steps to go ahead with their decision to go independent or to file on the ticket of a party.
Yes, well, still, if you feel that amounts vacating his position in Parliament, you still have to go to court for a declaration of effect. The Speaker was now making himself the judge.
So it wasn't in the Speaker's place to declare the seat vacant? Is that what you're saying?
That is my view. I don't know. Others may hold contrary view, but my view would be that it doesn't even have to be the Speaker. Any member of the House can do that.
Any member of the House could have gone to the court to have the seats declared vacant. The High Court.
Yes, exactly. He can go to the High Court. It's there. The provisions are there in the Constitution.
So, in the Speaker's decision, it was an overreach?
Well, I am not here to be attacking anybody, but I just thought that we are in a haste. That is the problem. Unfortunately, of course, the fact that because be an NDC man, that is what brings more tension. And if I were in his position, I would, since I'm supposed to be a neutral person, a Speaker, I would have asked those who were raising the issue to go and to the court to go and get the. That's what I would have done if I were in his position. But as I said, we all think differently.
So, if I understand you correctly, these individuals, per the Constitution, Article 97, 1G and H, they were automatically going to lose their seats because of their decision to go independent. But to have that being enforced, someone had to go to the High Court, and the court would then declare the seats vacant. Is that correct? Hello, sir. Can you hear me? Hello, sir. Okay, we'll have to Yes, can you hear me, please?
Yes, I can hear you. Can you
okay.
hear me?
Yes, I can hear you now. For a moment, I couldn't hear you. Did you hear my question?
Yes, I heard your question, but what I'm saying is that if the individual himself wants to move to the party and no longer be a member of the party, it is for him to take a decision. If he hasn't, you can go to court, challenge that position.
Okay.
Money.
So what about the provisions in the various parties, their constitution, which says that automatically you will lose your position in the party when
That is a
you...
matter for the party and the individual members. That is for the political party and the individual members. That is exactly what happened in the previous matter. It was the party that wrote. It was not the individual. It was the party that wrote Parliament. So the party can challenge the person. And I'm saying that any person, any Ghanaian who can move has the right to do that.
Okay.
Okay?
And what about those who argue that the place of the Supreme Court is to interpret and not necessarily direct?
What is the purpose of a Supreme Court making just a pronouncement in the air? That argument to me, they don't understand the legal process. As I said, if you are building a house and somebody comes to say to demolish the house and you go to the court on an ex parte motion, the court will direct that what? Stop what you are doing. And then come back and argue to tell me whether you have a right to do it or you don't have a right to do it. It is only done that the final pronouncement is made. But what they have done now is what we call an interim order. And the interim order has to be, because if you don't leave the status quo, the harm would have been done, and it cannot be reversed any longer.
Okay.
Have you got the point?
Yes.
That's the way the law works, or that's the way the law is meant to work.
Now, there are those who hold... I mean, since this issue came up, there's been a lot of conversation, as I mentioned in the beginning. There are people who have argued that, for instance, the Speaker was merely applying the law. He was not interpreting. And so, if it is said that it is out of his place to declare the seats...
Sorry, that's a very bogus argument. It is very bogus argument. You cannot be just interpreting the law. If you are interpreting the law, who has the power to interpret the law? It's Parliament.
And that is where the argument is that he was not interpreting, he was applying the Constitution as well as the rules of Parliament.
No, it is. You see, that is the Constitution they are making. Even if the Parliament, in its rules, incorporate the wording of what is in the Constitution, it does not still make it non-constitutional. It is still a constitutional provision.
Okay.
And in a constitutional provision, the power given for the interpretation of constitutional provision is only in the Supreme Court, not in any other court. That the law even says that if a matter is pending before the court and it requires constitutional interpretation, the court should stop what it is doing and refer that matter to the Supreme Court for them to make a ruling on the particular provision. Is there in the provisions of the Constitution?
Now,
I hope I've made myself clear.
Yes. With this particular case, the other argument is that at the time the leader of the NPP group in Parliament, Afenyo Markin, filed at the Supreme Court, no specific action had been taken. And so on what basis was he in the court? Because at the time, the former minority leader and member of Parliament for Tamale South, Haruna Idrisu, had spoken about it on the campaign platform, where he had said that when they resume, this was what was going to happen, because at the moment, 3 MPs on the side of the NPP, 2 of them have gone independent and 1 is going on the ticket of the party after coming into Parliament as an independent. And so on what basis was Afenyo Markin in court?
That was the more reason why he should go to court. If the person is threatening you that this is what I'm going to do against you, do you wait for the thing to happen before you go to court?
So he was working on speculation? You can go...
No, it is simple common sense. This is simple common sense. If you are threatening me that this is what you're going to do to me, I should wait for you to do the thing before I go to court. Is that it?
But then again, the courts don't deal with speculation, or...
That is a matter for them to go and argue when they go to the court. You don't get the point. What I'm saying is that all the questions you're asking me now does not arise because, 1, they are supposed to come back to the court.
Okay.
So let them go to the court and go and argue the matter and let the court make the ruling.
One more question that I need to ask that has come up forcefully is that, the speaker's ruling was not of a judicial nature. It's not executable, as has been said by many of the legal practitioners. It's usually executable actions are usually ones that are from the judiciary or the quasi-judicial bodies. In this case, nothing of that nature. So how exactly is the Supreme Court ordering a stay of execution?
This is what I find very strange and funny. If the Haruna is saying that on Tuesday they will come to court, this is what they are going to do, and the Speaker has ruled that there is a vacancy by virtue of that, what is executing you are talking about? What are they talking about?
Mm.
No, sometimes like people just don't even understand the way the judicial process works. It's amazing that I hear lawyers even arguing like this. It makes no sense. I said I spent years at the bar, being even the leader of the bar, and have been to the Supreme Court many, many times. Or not just Supreme Court, actually the court system for over 60 years. So I can't understand how anybody can be making an argument to say that when the Speaker makes a pronouncement, say he's making a declaration. And then the other side, the people will say, okay, we are going to, on Tuesday when we meet, we are going to change the rules. Or we are going to do this, we are going to do that. What is the other side supposed to do? They should wait until they go and make the appointments and the rest of them before they go to court. But that is not the legal process. The legal process is to prevent chaos. And so that is why courts do what we call interim order.
Okay.
Interim, the word is important. It's an interim order. That means none of you should take any steps until you come back to us and argue the matter, and then we can make a final decision. So no final decision has been made, and they are behaving as if final decision had been made.
And so
that is the order that has been made by the court.
And for those who say that, for instance, yes, you mentioned that the court is supposed to prevent chaos and also address issues of key interests where and timeliness is equally very important. One of the reasons. One of the main criticism that the Supreme Court has come under, especially on the back of this case, is that it appears as though they are selective with regard to the urgency they attach to some cases. In some cases, there is no urgency, and then the others they address it very speedily. And many say that most of these cases have to do with the executive or the side of government, like the majority group or even the executive itself.
That is also because they are talking about the process as if they don't even understand the way the things work in the court. Each matter has its own importance or urgency. There is no rule in the court which says that because this case must be tried before the other one is tried. And since they were starting the United States, they should go to the United States and find out matters which are pending there. Some of them will not even be touched at all. They just died. Since they were mentioning the United States, like they are foreign their jurisprudence, they should go and take their time and study the system there very well. Then they can be able to raise the argument. Each matter, the urgency depends upon what is involved. I'm telling you, if the question was that on Tuesday we are going to meet and we are going to change it, we will change that. How do you go and equate that with somebody who is talking about LGBTQ and so on?
No, one of the cases beyond the LGBTQ, one of the cases it cites, for instance, is the Domelovo case. At the time when it was happening, at the heat of it, CSOs took the matter to court because of the constitutional issues and all. But the Supreme Court looked at it 2 years later, and 2 or so years later, and said that the president was in the wrong. But at the time, when it was raging, the Supreme Court didn't act on it.
The Supreme Court is not a button you go and press and get results. There are human beings who are there. But I'm saying that they have their own timetable, or even you must even go and impress upon them that it is urgent for them to take this and this process. The law allows you to do that.
And
They cannot attack the Supreme Court because of this. That is what I'm saying, that these attacks don't help anybody, because when you are attacking the Supreme Court, which is the final court in the land, where else can we go after that?
Some say that it is the Supreme Court itself that is putting itself in that light, that perception is everything. If people have brought in cases which are equally urgent and the same urgency is not attached to them.
Who determines about the equally? Who determines that?
Once again, I'd reference the Domelova case, for instance, where an irreparable harm was definitely going to be caused. And at the time, the argument is that the Supreme Court could have quickly addressed the issue for it to be settled. But to have addressed it 2 years later.
I am telling you that those who took the matter there has a right to go to the court, to go and press upon it.
Which they did.
You remember that when the election petition went to the court. Do you remember that?
Yes.
You remember that they actually sat day to day?
Yes.
In order to do it. Well, now, who took the matter to the Supreme Court?
The NDC?
Was it not the opposition?
Yes.
Yes, and was that not tried?
Yes, it was.
Exactly. So what is the problem now?
So those making that argument now, they don't have it. They don't have a case.
This is what I am saying, that you can't raise the court, because the matter of this nature, it has to be done quickly. Because Parliament will be thrown into chaos. They only have 2 months.
Okay.
They have 2 months. Only 2 months, they'll be over. And therefore, a matter of this nature, it is so urgent that even they, as Parliament, should actually insist that the matter be tried early. And the court did that, the same thing. They give an interim order and say, come back in 10 days, file the document so that we can go into the matter. So I don't know why they're attacking the Supreme Court.
Now, the bit about the ex parte application, was that fair?
That's normal. That is the normal procedure.
Okay.
Yeah, it is a normal procedure. I'm saying that if somebody wanted to pull your building down, you will rush to court, won't you? What would the court do? Would the court say that, okay, go and file this document, file that document? No.
Okay.
They'll give an order first. Cease what you are doing. Come now before me and come and argue whether you have a right to do what you are doing. That is the process. So I don't see why even lawyers are arguing about this matter. It's as if they've never been to court, but they don't practice law in the courts.
And the final thing, which has equally been topical, is that the empaneling of the judges that sat on the case. Some have the claim is that because
the right to empanel is vested by the Constitution in the Chief Justice. What I'm saying is that if they choose 5 out of the number of judges which are there, and they have given an interim order, you go there for a trial, assuming for the sake of argument that a ruling is made against you. You have a right to ask for a review.
Okay.
The Chief Justice has to add numbers to that number again. It may be 7, sometimes even 9. That is the power which is reposed in the Chief Justice. Because there must be order in everything that we do. And if there's the order, there must be somebody who will take that decision. Is that not correct? Should an outsider tell them what to do?
The people in question, they've raised issues in relation to the individuals selected to be on the panel.
Saying that what they were doing was evil. It is not done. You don't go there and start naming judges because you are making them for attack. You don't do that. It is improper. It is in bad taste.
Well, we're just about wrapping up the conversation. You say that in the long term, in Parliament tomorrow, to avert any chaos, the Peace Council should step in as soon as possible.
Yeah, that's what I believe, that they should just spirit everybody to have to take a cool head and wait for the process to go on to complete. That's all. Because otherwise you're going to create chaos. Assuming for that they go to Parliament to say this person majority, and as they are threatening, they go and they will table this motion to repeal this law, to repeal that law, to repeal that law that they had passed through. Parliament has passed.
You know,
Because you think that it's an election, so that you can use that people that this is what we have done, so vote for us. You think that is in bad good taste?
you know, the Chief Justice yesterday was in church. She was I think she was billed to deliver a sermon of the sort, and she said that she's in the eye of the storm, and she had wished that this couple will pass her by. What are your thoughts? I mean, these are sometimes people say these are coded ways of people's expressing.
She's absolutely right. She's absolutely right. But she's being attacked left and right. You want her to go to this church and to go and pronounce pronouncement again. They will still attack her. Even me, as I'm speaking to you right now, tomorrow you will see the number of attacks that I'm going to receive. So sometimes even some of us have to shy away from radio stations and television stations because of that. We are being asked certain things like that. We refuse to speak, not because we are not citizens of Ghana, that we don't love the country, but because of this constant verification, attacks. They will make allegations against you. They will say, because of this, that happened, you did this and that. Things you never did at all. They will splash it at you. This is the whole truth. So the Chief Justice was right, that she's in the storm of the eye. She's very right. So let's just pray that this council and others will intervene quickly and have something done. Because somebody was talking about council state, that our process is slower because our people are all over the country, you understand? So you can't just call a meeting and expect, let's say, 2 days people will come. Because somebody are in the north, somebody in the east, somebody in the west. So it doesn't work like that. So at least the Peace Council is known to be a neutral body. So let them intervene.
And how has it been serving on the Council of State?
Well, it's exciting because we have opportunities to, we don't make noise about the things we do, but we've put tensions down many times, just by calling people. Sometimes even meeting at midnight. Yes, sometimes even meeting at midnight, just to create cool head and stop chaos in the country. So these are the things that we'll be doing, but we don't make noise about it.
So how do you feel when people say, for instance, that the Council of States is a white elephant? It's not been useful to the country, and to some extent we should scrap it when the opportunity arrives.
It's because they don't even understand the constitutionality and also the reasons why certain things are done. Look, Nkrumah was Prime Minister and President, right? He was doing everything he liked because there was nobody there to question him. So isn't it wonderful that at least you have an institution whereby if you feel that something is wrong, you can go to them and complain, and they will intervene. Isn't that a useful institution? We have only one parliament. Britain, they have both the House of Commons and the House of Lords. America, they have the House and they also have the Senate. 2 institutions. So one is supporting the other, one is checking the other. And we talk in constitutional law, we talk about checks and balances. Checks and balances. There must be checks, there must be also what? Balances. And so when you don't have those checks and balances, you can see the danger that is involved. Particularly our constitution gives so much power to the president that if you don't have institutions of that nature, he alone cannot be everywhere, he cannot see everything. So it is important for us to have institutions which can be able to intervene. If I'm telling you the petitions that we receive, it's quite a lot. And we deal with them. We call all of the people and dialogue with them and make suggestions for them. And in many instances, good things have come out of it.
Now, would you say that in terms of the Council of State and the work you have done in the past, there are times you give advice on key appointments and all that, and other very critical issues. Would you say that the president is a listening one in terms of your work and your interactions with him?
Well, that kind of question one should not ask, because I keep telling people that the advice that the council gives to the president are intimate, and we cannot go and announce it in public. And there is also forgetting that the constitution gives Parliament itself also to ask the council to intervene. It asks ministers, institutions also to bring their issues and problems before the council for counsel and for advice. But all this is being completely ignored. Yeah, so
Yes.
I think it's a complete misunderstanding of the, what we call it,
Yes.
the rule. But I also keep telling them, and in fact, I'm even telling you, the media, to say that you yourself should even arrange to ask the council to expound and explain the nature of the work that they do. But you don't do it. All we do is attack. If people are ignorant, you understand, because they don't know what is going on. And we are not supposed to go and be publicizing ourselves. So this is where we are. So I'm leaving the ball in your court.
In relation to my question about whether the president is a listening one or not, we're not asking for specifics, but in general,
we have meetings with him. We have regular meetings with him. And he sends memos to us. Okay. Yeah, we have regular meetings with him, and either on his call or we arrange and we go to have meetings with him.
Okay.
Yeah.
And he's always usually very receptive.
Oh, yeah. Oh, absolutely receptive. Normally he comes with his own entourage of people.
Okay.
We dialogue. We dialogue all the time.
All right, sir. Thank you so much for speaking to us. We're grateful for your time.
Pleasure is mine. Yes.
You had us speak to Sam Okudzeto, former GBA president and also a member of the Council of State. And we're talking about this raging issue in relation to Parliament and how things have unfolded. Look, it's been very fluid. From Thursday, when the Speaker first gave out the ruling or put out the information, and then the minority became the majority. The majority also became the minority, and then eventually they said that they were going to boycott the sittings until the substantive case was heard. And then the very next day, which was Friday, they went to the Supreme Court with an ex parte motion, and the outcome of that was a ruling by the apex court that the Speaker's ruling or information should be stayed. Well, the minority, which became the majority, NDC. So from here, I'll just refer to them as NDC group and NPP group. Now, the NDC group says that, listen, we are not, the Supreme Court's ruling is not binding on us. We are going to listen to the Speaker. Ibrahim Alassane asked them what they think the Speaker of Parliament's decision will be. Ato Forson says, well, I'm not the Speaker. When we get to the House, we would know. And among other issues, they say that when they get to the bridge, you know how to cross it. But before the oppressor, we also did hear the NPP group after the court proceedings saying that, Charlie, they didn't say Charlie, I've added that one to it. They said that, well, we told you that we know how to follow due process to right the wrong. And they believe that the Speaker should not have gone ahead to give the ruling, especially when a matter was before the Supreme Court. Right now, all eyes are on Parliament tomorrow. Ibrahim Alassane is here with me. Look, the conversations will not stop. Yeah. I can say that between Thursday and Friday, between Thursday and Sunday, the volume of legal write-ups that we have seen and commentary. Look, I swear, I'm sure those who have not even been to the law school are already mini lawyers.
Well, at a point, I'm sure we will have to just go to GA today and listen to Mahama Ayariga.
There are also lessons going on there.
Whom Sam Okudzeto referred to profoundly in his submissions. But yes, now it's quite interesting. You have a decision that has virtually divided. In fact, I've heard Professor Kukwasari.
Yeah.
His argument is that two wrongs do not make
it right, yes.
And when it comes to the decision of the Supreme Court, he's decided not to advance legal argument. He's saying that cool heads must prevail. And that given the time we find ourselves in this, that. And I've seen that he and Manasseh have been going at each other. And the fact that we are a few months to an election, sometimes you have to read the room. So he expects the speaker to read the room. There are many others who also expected the Supreme Court to read the room, right? Good. Manasseh has returned and said, no, you see, you are looking at December 7. No, it's way beyond December 7.
Yeah,
it's about decisions that are made in this country and implications and
of later years.
And how many must equally be made to read the room.
Yeah.
I remember a few years ago when Justice Atuguba.
Okay.
Justice Atuguba and co were there. We're told that there is the proper spirit and letter of the provisions in the Constitution. And sometimes, even at the apex court of the land, they read the ambience in the country, the temperature,
yes,
everything, and that is factored into decisions that are made. Others will argue that it's still the case, but there are many who disagree that that's no longer the case. It's like, and of course, you just heard me relate to a headline from a story attributed to Hannah Tete, who is asking whether the apex court of the land addresses its mind to the sentiments of the public. Now, so that's one.
Yeah.
Two, and then the very first person I've heard argue on law in favor of whatever has happened is Sam Okudzeto Ablaka, the man who just spoke to, the former GBA president and a member of the Council of State. Even he thinks that the Chief Peace Council must come in. Because if you do change, we'll all be bent.
That's true. And that's what he was saying, that you don't know who will be at the receiving end.
Exactly. And so sometimes decisions must bring finalities.
Yeah.
You expect decisions to bring finalities.
Not further confusion.
And that's where the problem is.
Yes.
There are many people who have received messages who say they are much more confused now than they were.
I am confused.
So, Mahama Ayariga is on GA today. He's also talking about the fact that the jurisdiction is wrong. We can just cross and then pick that.
Okay.
Ima can ensure that we'll do that. Yeah, it's still on.
Okay.
Ima can ensure that we cross and we take that. And that's better. So the point is, he's arguing that the High Court is seized with the jurisdiction as far as...
And that is an argument Sam Okudzeto equally made, that it is not in the Speaker's place
Ayariga's choice is not in the Supreme Court space. You see? So they all agree that it's the High Court. But it is who is wrong in referring the matter to the High Court and who is not wrong.
No, but you see, the problem is the inconsistencies of our application of our laws. If in 2020, a professor of law, a professor of political science, is it political science or law?
I think he's a lawyer. Okay, he's a lawyer.
And he's a lawyer too, but he's a political
he's a professor of political science, yes.
No, and he being a lawyer as well, he gave this ruling. And imagine at that time, he probably stayed his hand from this issue. We will not have had the need to get through it at this point. Because you see, like Manasseh was saying, it's not about today.
No.
At that time, it was for the 2020 elections.
Yeah.
But look at what it has landed us into now.
Yeah.
In 2024, where now, because the numbers are so close with a difference of 1, this has become an issue.
That's the point.
So we leaders, as we keep saying, I mean, we put you in a position of trust. And so we expect you to equally have a futuristic perspective about things.
Yeah.
It's not just about, okay, because you see, the fact that someone is applying the law does not make it just.
Yeah.
Do you understand?
Of course.
Because there are a lot of times where people have used law to abuse people.
Oh, yes. Yes, of course.
So the fact that it is stated in law does not make it just, because people advocate for their interests.
That's true.
Their interests, sometimes the loudest would have theirs supersede.
Yeah.
It does not necessarily make it the right for everyone.
True.
And so we all need to take a step back and really reflect. This thing about everything, let's go to court. We are becoming unreasonable.
Yeah.
We are failing to have conversations.
Yep.
And if you fail to have conversations, this is what we are going to have: anarchy, confusion.
That's true.
Well, let's quickly cross over to our sister station, GH1 Television, where Mahama Yaraga is also there with the Member of Parliament for Anyaso Utum, Dr. Dixon Adomako, and they are talking about this same issue.
In the conduct stipulated in A to H, that the Speaker should go to the High Court and get an order to declare the seat vacant. I said 97.1 says that you, the MP, 97.1 is giving instruction to you, the Member of Parliament, that you shall vacate your seat. I said, what in this direct, order of the Constitution is so ambiguous that it leads to one going to import an understanding that you should go to the High Court and get an order? I said, now you go to 99, and 99 says that if there is an issue that needs determination,